Hello everyone, I am here with another client question today. I literally just got off the phone with the client and this was involving an intestate probate matter, which means the person died without a will. This client is highly upset because the administrator who was appointed the administrator is not giving them as much information. They don't feel like the administrator has done what they're supposed to do. And one of the questions was, well, can we force the administrator to give us the reports about the estate? And so we started to discuss the acknowledgement form that you sign when you sign for the agreement of an administrator for the letters of administration in the petition. So there's an acknowledgement form that you generally get as an heir to an estate if there is a person filing to be the administrator for the petition for letters of administration. So basically, if someone passes away without a will in Georgia, you all know that they have to go through probate, and the person who wants to be the administrator of the estate has to file for the petition for letters of administration. So my point in today's video is to explain the acknowledgement form in the petition for letters of administration so that you understand what you are signing when you when you do this. When you sign this form, that you understand what it is that you're signing. So ultimately, you have to be considered an heir, and there are specific laws in Georgia about who's considered an heir. We can definitely go over that in another video, but in order to receive an acknowledgement form, you have to be considered an heir. And basically in that acknowledgement form, there are several things. The first thing is the statement of heirship. So basically the form is acknowledging that you are an heir and you are agreeing that the heirs that are listed in the petition are the heirs of the estate. You're also agreeing to notice of the form and the petition for letters of administration. So you're agreeing that I have read through the letters of administration, I agree to who the heirs are, and I am receiving notice of this. So the court is not going to be required to send this out to you because you have already received it. You're also agreeing to the appointment of the administrator. So you're stating in this acknowledgement form that the person who is requesting to be the administrator of the estate through this petition, you are agreeing that that person can be appointed. And you're also waiving any objections to the appointment of that agreement. You're also agreeing to the waiver of bond. Bond is very important. A lot of people don't realize how this affects the estate if there's something that happens or that the fiduciary does to the estate. The bond is what they post to make sure that the estate assets are protected. So you're agreeing, if you initial next to that section, that this person does not have to post bond. So you're agreeing that you don't need protection of the estate assets. And then you're also agreeing for waiver of inventory and returns. And this is where I was explaining to my clients that, you know, when you make this agreement, you're stating that the administrator does not have the duty to file an inventory with the court or annual reports with the court. And those are generally the documents that kind of keep the heirs informed through the probate court on what's going on with the estate. So although them not having to do waiving the waiver of inventory and the waiver of reports does simplify the estate. It makes it easier for the administrator to just go through the process. It can be an issue if these heirs don't have any idea on what's going on and have no recourse to finding it out. So, and then lastly, what you're acknowledging is for further notice. So sometimes you may give up the right for the court to give you notice on any future filings or hearings. That generally doesn't happen. The probate court will generally keep the heirs updated. But sometimes if there's not anyone contesting and everyone has agreed, they will only send out the future correspondences and notices to the administrator, to the petitioner at the time who's petitioning to be the administrator. So before you file this acknowledgement form, you have to make sure that you're okay with this person being the administrator. That's the number one thing, because you're agreeing to them being the administrator. Do you trust this person to handle the property? If not, then you don't want to waive bond or inventory and reports, because you want to know what's going on. And then if something happens with the estate property, you want to make sure that it's protected. Do you want the court to be involved with the oversight? That's the piece of the inventory and report. And reports is to make sure that the court is still involved in what's going on. And then if you're unsure or disagree with whoever the petitioner is, then don't sign the acknowledgement form. Speak with your probate attorney to decide if this is something that you should do. And if you don't agree, you don't have to sign. It's not required. It does make the estate process a little easier if everyone is on board, but if you are not, then please protect your rights and do not sign. So if you have questions about the probate process, our firm hosts consultations on probate, as well as estate planning, guardianship, conservatorship. And so please feel free to reach out to our firm if you are in that process and need more information. Thank you.